So let me take you back just a bit. Again, oftentimes the focus is on the 1950s and the 1960s and those events, but I think it's worthwhile, since it really hasn't been covered in this course certainly, to drop back and pick up a bit of the history leading up to, for instance, the Brown decision in 1954. Some we covered, some it's worth review. First of all, let's go all the way back to the turn of the century. Let's go back to the early 20th century here. And think about the varying ideas of what the path for African Americans ought to be in the midst of Jim Crow segregation being enforced and political or voting rights being denied through disfranchisement. And really there are two camps, and that's often the case. On the one hand, you'll have the accommodationists. You'll have the people like Booker Washington who advised African Americans not to struggle overtly against the repression of being denied the vote so much as to build themselves up economically and socially until they became such a force that they could demand political equality. Show yourselves worthy, in other words, of middle-class white notions of appropriateness, and the time will come when you can demand what is yours. The phrase that became so much associated with the so-called Atlanta Compromise going back to the 1890s would be this notion to put down your bucket where you are. In other words, don't wait and go thirsty, but focus on the things you can change, the things you can make work on your behalf, so that you build yourself up, or in other words, as he might have put it, build up your race, and then your ship will come into port. You'll survive. There's another voice at work here too, and it's often associated with W.B. Du Bois, and it suggests that really African Americans ought to focus on demanding what is theirs by right. Don't wait. And don't think so much about pulling or uplifting up everyone as the so-called talented 10th. Those who are already educated, those who are already lawyers and doctors and professionals in their own right, who enjoy much of middle-class existence in terms of lifestyle and standard of living, let them be the leaders and let them push for securing those rights which already belong to African Americans under the Constitution. Well, in 1909, Du Bois and a number of other African Americans put together or organized the NAACP, the National Association for the Advancement of Colored People. This organization will be integral to the civil rights movement from the early 20th century through the First World War, the 20s, the 30s, into the 40s, and particularly leading up to Brown. Predominantly, the challenge of the NAACP to segregation and to a denial of voting rights or disfranchisement will be legal. And that's really where I want to start this out. But let me throw in another thread here. In both World War I and World War II, you've noticed African American service. And Melanie Story will have talked about the Double V campaign, the notion that African Americans would be foolish not to ask the question in the midst of war fought against fascism and authoritarianism, what sort of world they'll go home to when the war's over. In other words, don't they face many of the same kind of threats when they go home? So it's not just a war against fascism, it also becomes very much, World War II does, a war to change America. There's also, coming back to World War II, there's also the story of A. Philip Randolph. And his threat in 1941, talking about equal treatment for African Americans in particular under defense contracts, and talking to Franklin Roosevelt and saying, look, if we can't get equal treatment or even jobs assured under these defense contracts, then one option available will be to march on Washington. To march on Washington. A. Philip Randolph, the head of the Brotherhood of Sleeping Car Porters. Franklin Roosevelt responds with the Fair Employment Practices Commission. It's kind of a half-hearted measure, but it's more than had existed to try and protect some opportunities for African Americans in defense work. And then there's Harry Truman. You know, don't forget that in 1947, Truman has put together a commission to study civil rights in the United States based upon the response, the threats, the violent incidents that had occurred with African American veterans after the Second World War. And the commission comes out with what ultimately is a sort of national or federal plan for civil rights for 20 years hence, 20 years on, to secure these rights. It's not as if suddenly civil rights pops fresh from the vacuum in the 1950s. It just ain't so. African Americans have been struggling for these rights since Reconstruction, and that struggle will continue in the early 20th century. But it's in the 40s where we see A. Philip Randolph, where we see the creation of the Congress of Racial Equality, an interracial political group, 1942, and where we see court cases beginning to come to a head or bring to the courts these questions of fair treatment to challenge the very essence of segregation, separate but equal, right? The doctrine of separate but equal. In the 1930s, the NAACP is actively challenging, and they're trying to do so in ways that are strategically and, well, perhaps tactically advantageous. One of these ways is to go after educational inequality. Not necessarily with children, which could raise real issues with white parents, but in professional schools and law schools. One of the first cases that I want to make an example of here is the case of Smith v. Allwright in 1944. And the question in Smith v. Allwright is a question of the all-white primary. Basically, the argument, and this is a court case that's launched from Harris County, Texas, a fellow named Lonnie Smith, is that because African Americans are denied the right to participate in the Democratic Party's primary elections, in which candidates are selected for the general election, and because the Democratic candidate is going to be the winner of the general election, in essence, African Americans are denied a say in the general election. Let me see if I can say that more simply. If the candidate is going to be Democratic in the general election, and that's going to be the winner because Democrats dominate this particular county, say Harris County, and if that candidate for the Democratic Party is then chosen in a primary in which African Americans cannot participate, then de facto, African Americans are not having a say in the election of their representative for Harris County. So the question in Smith v. Allwright is the question of the all-white primary, or the lily-white primary as it's sometimes called. And the Supreme Court decides in 1944 that these all-white or lily-white primaries are unconstitutional because indeed they do deny citizens the rights that they have as citizens when it comes to the vote. And we go back here, think about it, to the 15th Amendment. (1950), another major year, and there are two sort of examples that I want to bring up here before we get to Brown. Number one is the case of Sweat v. Painter. This case involves the University of Texas Law School. And basically the question was whether or not equal education but separate education was acceptable. In other words, whether or not the University of Texas could effectively farm out an African-American law student to a specifically African-American law school. Now, the idea was, as early as 1947, that Texas would create an African-American school of law separate from the University of Texas. But that hadn't really happened. And the court says it doesn't matter if it happens because ultimately that law school, by being separate, would be unequal. It would inherently be inferior. The experience of this law student, in spite of race, being that he is going to be there, pretty much alone, certainly in a smaller group and without connection to the law students at the University of Texas, would automatically place this law school as subpar and thus unequal. What's happening in the professional schools like the University of Texas and in Sweat v. Painter is that the NAACP is finding ways to challenge in the court system the very doctrine by which segregation has been protected under Supreme Court decision since Plessy. Another important case is McLaurin v. Oklahoma, McLaurin versus Oklahoma, also 1950. In this case, we're talking not about law school, but we're talking about a student who is seeking to get an advanced degree, a PhD in education, has already gotten a master's, now seeks a PhD, and so requests admission to the University of Oklahoma. Indeed, this African-American student is granted admission, but will be segregated within the university. That is to say that this student will be given a separate desk in a separate area of the class, a separate place to eat in the cafeteria, have to find separate restroom facilities. Basically, that this student can be in the midst of, but not part of, the educational process. And the result of that, the court decides, is unacceptable. That the result is inferior. That the treatment is unequal. So by 1950, by 1950, the NAACP and African Americans have already established precedents in the United States and in the court system that would challenge, under particular circumstances, namely professional schools, challenge the validity of the doctrine established in Plessy v. Ferguson, separate but equal. That helps, I think, to set the stage for what's going to follow in the 1950s. And we'll pick up the story there in the next segment.